Good morning and welcome to the Cyber Law Seminar hosted by the MDDA this morning. The Cyber Law Seminar will be a four-part session in terms of the topics that we're going to be discussing. But before I do that, let me just introduce myself. My name is Sizwe Snail Gamtuze. And with me is Advocate Unathi Ngogweni, who will be assisting me today with this seminar. So without wasting any further time, that is the outline for today. Welcome of delegates and introduction, as we've done now. I will kick off to discuss cyber crimes. After cyber crimes, we'll have a 5-minute break. Then Advocate Ngogweni will take over the Protection of Personal Information Act session, whereafter we'll have a 15-minute tea break, and then I will be your captain for the remainder for the protection of privacy in the online space, as well as freedom of expression. After each of the formal presentation, we will allow for Q&A, so you will be able to ask questions and we will be giving you insights on that as well. So that is the outline for this morning. I just want to switch over now to the presentation that we're going to be using on cyber criminality. Right. In a moment or so, you should be seeing what I am seeing already. Let's see. Right. So the first topic for the morning will be cybercrime in South Africa, as well as the development of cybercrime. What's nice about this morning's presentation is that we're going to cover cybercrime as it was known in the ECT Act, and we will also have an opportunity to go and explore the new Cybercrimes Act, Act 19 of 2020. So before the ECT Act came, we used the common law as it was. In other words, for crimes relating to online fraud, we would charge you with fraud, with malicious damage to property, in other words, damaging an information system. We would also charge you with that common law offense. But as early as 2002, the ECT Act came into law, the Electronic Communications Transactions Act. And in terms of the ECT Act, there was a dedicated chapter that specifically dealt with cyber criminality. Now, the reason why I'm still dealing with this particular aspect of the ECT, we know that as of the 1st of June, we have the new Cybercrimes Act, but those provisions are yet to come into full force. So it is important to still cover the ECT Act. So Section 86(1) of the ECT Act relates to the intentional accessing or the intentional interception of a information system or a communication that is being made. So in terms of Section 86(1), anyone who unlawfully intercepts a communication would be guilty of an offense. Now, Section 86(2) talks about the intentional and unlawful interference with data. In other words, what would interference be? That would be the modification of data, the destroying of data, the defacing of a website. That would be an act of interference or modification of data. Section 86(3) and 86(4) primarily deal with the what we call the anti-cracking and the anti-hacking. In other words, anyone who provides anti-circumvention tools or devices, software, who makes or designs SAME and makes it available to the public, he or she will be guilty of a criminal offense. And anyone who also, produces anti-circumvention technology will also be guilty of that offense. Section 86.4 primarily deals with copyright. Anyone who overcomes copyright protection on a DVD, for instance, that person would be guilty of an offense. Now you'll see I've put a DVD there. We obviously, most of us don't even use DVDs anymore. and I think that's the whole issue, because in 2002, movies were on DVDs, movies were on CDs. And when you put in the CD into the device, there were certain devices that could stop you from copying those movies. But as we all know, at the time I was a student, so I was busy copying DVDs, DVD rip, copying in the ICT lab, just like all the other students. But yes, we were never prosecuted, and thanks God for that. So we also have the denial of service attack. So the denial of service attack is the one where you attack an information system. In other words, you attack a computer system, either rendering it partially useless or completely useless. So anyone who commits the acts from 86.1 to 86.4, and in doing so hinders someone from using an information system, even a partial denial. Let me just make an example of what a denial of service would be. For instance, a disgruntled employee of a telecoms network puts a virus into one of the big telecoms networks, and as a result, the telecoms network phone calls are cut and certain people cannot call each other. That would be a partial denial, okay? Because the network is no more working optimally as a result of this malicious virus that has been put there. Now, it's not just about the ECT Act. We also have RICA. Everyone always thinks RICA has to do with the SIM card issue. It does have to do with the SIM card issue, but it also has to do with the prohibition of unlawful interception. I think we all know the recent case of Amabungane versus the Minister of Justice, where parts of the RICA Act, in particular relating to surveillance, were struck down by the Constitutional Court, and the RICA Act also allowing for certain, should I say, interception to happen in the case of an emergency, serious criminal offenses. It reminds me of the case of State versus Twele. For those of you who want to go on SAFLI, go and have a read at that, where an interception order was given by the court against the defendant. And also the exceptions relating to state security as well, obviously. And what I think is also important is that we need to know that you can't just monitor your employees' communications at work. Interestingly enough, in the news, about 2-3 weeks ago, there was a big story about the South African Broadcast Corporation that had included a clause specifically to be able to monitor the communications of their employees. And that was done specifically to counter the section in RICA, which is section 5.1, that says you must give written permission in order to have your communications intercepted or monitored. So it is commonplace in the private sector that such clauses are included in some of the employment contracts. But like I'm saying, quite recently, and this made headline news, the SABC confirmed that they would be removing that clause. Now, it's not just about RICA as well. We also have to look at the Prevention of Organized Crime Act, read together with the Financial Intelligence Center Act. And this is in the context of online Ponzi schemes, I mean, we've seen in the last 24 months big Ponzi schemes, especially being used in the form of cryptocurrency. In terms of prosecuting those people successfully, one really needs to have a multi-pronged approach in terms of the law to successfully prosecute these perpetrators. And then the Copyright Act as well, it actually has a provision that criminalizes the unlawful copying, be it of a movie, be it of a song, be it of any thing that you get on YouTube, for instance. But mostly the record companies are more interested in the people who are unlawfully reselling, because there's usually a very, very thin line between what we call fair use, in terms of which you can review music, you can listen to music, like on YouTube freely, you can review it, and that would not necessarily be an infringement either in terms of copyright law or in terms of the criminal aspect in the Copyright Act. Then we also have the Harassment Act as well as the Hate Speech Act. Now, the Harassment Act was specifically amended so that, the definition of harassment is big enough as to allow for harassment in domestic relationships, harassment in the online space. I've seen the Harassment Act being used very powerfully in the Children's Court, as well as some of the lower courts, in terms of online harassment, be it by way of social media or the likes. So we have very, very strong protection there as well. And then in terms of the Promotion of Equality and Prevention of Unfair Discrimination Act, we have the famous case of ANC versus Penny Sparrow. I think that's the case that everyone knows, where Ms. Sparrow referred to certain black people as monkeys at a beach, and as a result thereof, she was charged in terms of this act, and she was actually found guilty, and she was fined. You will hear later on, when we talk about freedom of expression, another well-known radio personality had something to say about what Penny Sparrow said, and he got into hot water. But we will get to that at a later stage. Right. Then we also have child pornography. As we have it, we have the Films and Publications Act as it stands relating to child pornography, as well as the amendments to the Films and Publications Act, which must be seen as coexisting with the criminal law, in other words, the Sexual Offences Amendment Act. And child pornography has really been defined there. It says, any image, however created, or description or presentation of a person, real or simulated. In other words, it could be a real video, or it could be a animation of a video, or, as we know, we like to make memes these days, right? Where there is a depiction or a description of someone who is under the age of 18. In other words, for it to constitute child pornography, that person who is depicted or is being simulated in that video, in that graphic, must be someone under the age of 18. And then there's a whole list of descriptions, in other words, where the child is engaging in a sexual offense, where the child is engaging in a sexual act of penetration, and the list goes on. But we will make the slides available after the presentation, as well as the reading material that has been provided to you, where all the instances are dealt with. I'm just mindful of time, so I'd like to proceed. Now, electronic evidence is still regulated in terms of the ECT Act. So it is critical that we deal with the ECT Act lastly in this particular context. So Section 15 basically says that a data message that is made in the ordinary course of business or a printout correctly certified, in other words, by way of affidavit, is rebuttable proof of the email evidence. Right. So that is the first leg to Section 15. And then Section 15 has also got the other legs that talk about the admissibility of the evidence. In other words, the electronic evidence will always be admitted, right? It will always be admitted into evidence. We know the case of the Honorable Judge Mutata, where cell phone evidence was used against him. And if one reads the decision therein, reference was made to Section 15 and the regime there. So Section 15 says all electronic evidence is admissible. So the school of thought that electronic evidence must still be considered by the court, that's old. As of 2002, all electronic evidence is admissible. The court will consider it. What the court, however, will have to do is look at the evidential weight. Hence, I'm referring in the slide to admissibility on the one hand, which we've spoken about, and evidential weight on the other hand. So the evidential weight will be considered with due consideration of how the data message or the video, in the case of Judge Mutata, how it was stored, how it was generated on a cell phone, how it was further communicated, how it was further shared, and any other relevant factor. Maybe the video was doctored, there were some amendments made. Those would be factors that deal with the evidential weight. So very, very important. All electronic evidence is admissible, but you can question the evidential weight of the evidence based on the criteria that I've given you there. Okay, so enough of background to cybercrime law. I see that I've made a small typo there. It's the Cybercrimes Act 19 of 2020. And I think the reason why I made a mistake was because it was put into law this year. Okay, so on the 1st of July, all right, the Cybercrimes Bill entered, the different phases of its parliamentary discussions. And this was also when the POPIA entered the grace period, interestingly enough. And when the 1st of June came this year, and that also coincided with the POPIA and the grace period, the president then signed into law the Cybercrimes Act, Act 19 of 2020. As you see there, at least I've written it correctly. So what was the whole idea of bringing a new act when we already had the ECT Act? Well, it had been already 18, 20 years since the ECT Act was drafted and finally made an act. And in the last 20 years, technology has evolved. Cyber criminals have become smarter, as well as the criminal sanctions that were provided for in the ECT Act. Some of them were, one could say, negligible, to say the least, because prosecutors, for instance, would prefer to charge you still with the common law offense of fraud rather than the e-fraud as contained in the ECT Act. By the way, 87.1, 87.2, 87.3 of the ECT Act, and I see we didn't discuss those, deal with e-extortion, e-fraud, and the third one will get to me. But those are covered here as well. So just a breakdown of the substantial parts. There are other parts in the Cybercrimes Act that deal with procedural issues, but the substantial parts, in other words, the nyama, the do's and don'ts, and as well as the sentencing aspects thereof, as well as some interesting court orders now that the court can give to victims of cyber criminals. Those are all contained in the first 6 parts of the Act. Okay, so Section 2 and Section 3 relate to, obviously, the unlawful securing of access, be it of a data or computer program or computer data storage medium or computer system, right? Anyone who unlawfully acquires data in terms of that will be guilty of a criminal offense. This is quite similar to our old Section 86(1). And Section 4, anyone who unlawfully or intentionally overcomes protection measures. This reminds me of Section 86(3). Remember, anyone who overcomes security measures or produces a device to do so, or acquires data by way of having overcome protection measures that were put in place, anyone who does that is also guilty of a criminal offense. Now, Section 5 states anyone who unlawfully and intentionally interferes with data or a computer program will be guilty of an offense. And for the purposes of interfere with a data or computer program, those definitions must be looked at widely. Data must be looked at widely, and interference must also be looked at widely. Now, Section 6 makes it unlawful for anyone to intentionally and unlawfully interfere with a data storage medium or a computer system. So anyone who goes and hacks a system, attacks a system that he or she is not authorized to do so would be guilty of an offense. Now, interestingly, for the purposes of this particular section, interference with a computer system means either temporary interference or the interruption or the impairment or the stopping of the functionality or the breach of confidentiality of the system, or even the integrity or the availability of the computer data storage medium. Those are all deemed to be acts of interference. Now, unlawful acquisition, possession, and provision, receipt as well as making available passwords, access to passwords, cracking passwords, giving software or making software that cracks passwords would also fall under Section 7. Right. Now, cyber fraud, cyber forgery, cyber uttering. Cyber fraud is nothing else but the electronic version of fraud. The intentional and the unlawful making of a false representation in order to get a benefit, or even a potential benefit, as we know from the case law. So that's cyber fraud, cyber forgery, anyone who produces or manufactures, be it a website, be it a payment method, be it an email, purporting to be from someone, it won't just necessarily be fraud, but it may be forgery because a document may have been produced. And then obviously the uttering is the aspect where you produce the forged electronic document and you pass it off, and that is the uttering aspect of it. Now, Section 11, you're going to say to me, but this is just a rehash of the old laws. To some extent it is, but as we proceed with Section 11, you will now see that we have aggravated offenses. So anyone who commits an act in terms of Section 3, Section 5, and Section 6, or Section 7. So let's just go back there quickly. So anyone who unlawfully accesses a computer system, anyone who overcomes a computer system, anyone who interferes with a computer system, right? Anyone who does so to a restricted computer system. Now, a restricted computer system is a new type of system. That would be what we call an aggravated offense. In other words, it's an offense that is even worse than the the offense as it would be in 3, 5, 6, and 7, if such is done to a restricted computer system, and those would be computer systems that are either under the control of the state. So if you go and you hack any organ of state, you go and hack their computer system, or you interfere with their computer system, you are going to be prosecuted in terms of the aggravated offense. Also those who mess with banks, as you can see, financial institutions, there will be aggravated offenses there and aggravated sentences. And anyone who also interferes with the computer systems relating to the courts. Interestingly, we are using a lot of computer systems in the courts now, so that section is very relevant. Then we have malicious communications. Anyone who discloses electronic communication services or a data message in a group or persons or in public with the intention to incite unlawful violence. Now, this is an interesting one in the context of what we are seeing of what happened in our riots the last month and a half ago. You see, this one specifically deals with anyone who uses social media, electronic media, Facebook, Twitter, WhatsApp, you name them. Anyone who uses those platforms to incite violence, to damage property, that person would be guilty of a criminal offense. Section 15, anyone who discloses a data message and threatens any other person's person with damage to their belonging or a related person, that would also be a criminal issue. Now, Section 16, and you've seen I've written it in big, is the revenge porn provision. Now, I really don't understand why people are having porn of themselves in the first place, but it's a free country. So people do have porn of themselves, and people do share this pornography with their partners. Unfortunately, you don't know what will happen 5 to 10 years. Well, that was the issue, and you had to be scared about that before Section 16. Because before Section 16, they could do nothing. But now in terms of Section 16, if that disgruntled lover decides now, 5 years later, to publish a video or a picture, whatever, an intimate picture at the time, or a clip from that relationship, and you did not agree to that, that will now be also a criminal sanctionable act. So for those of you who think out there you can use revenge porn to harass people, good luck. The Cybercrimes Act is here to deal with you. Right. Anyone who attempts, conspires, aids, abets, induces, instigates, instructs or commands or procures anyone to commit a crime as stated in the Cybercrimes Act is guilty as well. Right. Now, we also have the provision of competent verdict, right? It means that if the evidence in a criminal proceedings does not prove the commission of an offense that he or she was charged with, but is a contravention in terms of Section 17A in respect of the offense charged or in respect of any other offense. So you could have been charged with hacking, and then you can be further prosecuted with hacking as well as having, taken the data unlawfully. So it's the act of hacking and the act of stealing. So you may have just been charged for the act of hacking, but, in terms of a competent verdict, you could also be charged with the taking of the data. So, as you can see now, we have stringent fines and prison sentences. If you are found guilty in terms of Section 2, 2.1, 2.2, 3.3, or 7.2, you will be found guilty for a fine or imprisonment not exceeding 5 years or both. So it could be a fine and imprisonment. If you are found guilty of 3.1 and 3.2, 41, 51, 61, and 71. And by the way, as much as I'm referring to all these sections, there is going to be a handout and the slides will be available for you. So don't worry, it will be digestible. You'll be able to digest this even after, right? Anyone who's found guilty of those offenses will be guilty of 10 years and a fine or both. And then anyone who's guilty in terms of 19.3, in other words, 11.1, those aggravated ones, 15 years and a fine. So I always used to say, it seems as if cybercrime pays in South Africa because of the small sentences that they had, but clearly cybercrime does not pay any longer. You will be going to jail and the prison sentences are quite big. I don't want to discuss too much on sentencing. I think what's important is that we understand Section 20. Now, Section 20 is beautiful. So if anyone is harassing yourself, your person online, or is inciting people to attack you, or anyone who is intending to share revenge porn, Section 20 has got a beautiful mechanism now. Whilst the criminal investigation is taking place, you can ask for a protection order to stop the perpetrator from doing so. So not only do you charge the person with revenge porn, but you can also go to court and get a court order to stop that person from further disseminating the revenge porn. Or you can get a court order to stop the person from further harassing you or further intimidating you or further procuring other people online to commit acts of violence against you. Right. Now, the Cybercrimes Act has 9 chapters. We can't possibly discuss all of them. So we discussed chapters 1 to 3. There are certain powers to investigate, search and seize and access certain evidence, and these are set out in sections 25. And sections 26 also talks about a standard operating procedures that must be developed for the search and seizure of electronic evidence. Also, the applying for a warrant by way of oral application. In other words, you don't have to now go and draft a long affidavit. You can go to a judicial officer and orally explain. You can say, look, here's this website. You can bring your laptop and say, they are currently running child pornography now. I need a court order now. And the judicial officer can grant that order on oral application, which is really great, and get an order either to take that information off or to preserve the electronic evidence for later prosecution. So this is really, really great. Section 34 makes it obligatory for an electronic communication service provider or a financial institution or anyone who's in control of information to assist the police in providing technical and any other assistance in the investigation. So we know that some of these crimes take place on the servers of financial institutions. We know that some of these crimes use infrastructures of electronic communication service providers. We know electronic service communications providers, in terms of the ECT Act, are a mere conduit. We know that. However, Section 34 now makes it obligatory for them to assist in providing technical assistance and any other assistance when it comes to the investigation of cybercrime. So this is really a multi-pronged, multi-stakeholder approach designed to really go for good investigation and good prosecution of cyber criminals. And the powers go on right up to sections 41. These are really procedural powers. I don't want to dwell on them. They are contained in the material. Then there's also mutual assistance between countries. Our National Director of Public Prosecutions can talk to the DPP of another country, and they can enter into mutual assistance agreements relating to prosecution of cybercrime. What is also beautiful in terms of Section 52, and I wish to really, really compliment the powers that be for this one, is that, up to now, there would be a cybercrime. You would go to a police station 9 out of 10 instances, the police there would not know what is Section 86.1, 86.2, 86.3, 86.4, Section 87, 88, 89, and the likes. You would most probably open the case and then after that have to follow up either with the guy's superior, then go and follow up with the people in Pretoria. Maybe you're from a remote town. That's the end of that. There will now be a designated point of contact for cyber crime notification, and this is great. So there will be one central point where you can report cyber criminal activity of the SAPS, and this will ensure that you will get the right attention from the right trained police officer who knows how to deal with cyber criminality. Hence I say I take my hat off to the powers that be for this one. They really, really listened to the people on this one. Then Chapter 7 deals with electronic evidence, but not Section 15. That's why I still taught you Section 15. So Section 53 deals with the evidence of a forensic expert, a computer scientist, all the type of experts that you may have to call to court. Sometimes you may not be able to call them, so they can adduce evidence by way of affidavit, attach their reports, and thereto. And then Chapter 8 just talks about reporting obligations, that, there are reporting obligations in terms of the Cybercrimes Act that service providers must, within 72 hours, report any of the cyber criminal activities that take place on their network. And the police must also build capacity with regards to investigation of cyber criminality, as well as giving the right police officers the right equipment, the right knowledge to assist people with bringing their cases. Now, we've reached the end of the formal part of the presentation. We can open the floor for some questions. We will open the floor for some questions. And I'm glad to say we seem to be good on time. So can we open the floor? I see 2 participants have raised their hands. Let me see who they are. Okay, Mxolisi Dongeni. I recognize you. Mxolisi, we can't hear you. Okay, looks like we've lost Mxolisi there. Okay, there's Mxolisi again. Mxolisi? Let me see. No, the issue is not on our side. Maybe, Mxolisi, you can text your message because I see your mic is on. Can I pass to Sean? Sean, can you switch on your mic? Let's see. Okay. Sean, I recognize you. You need to unmute yourself so that I can hear.
Am I registered as Sean?
Yes, you are registered as Sean. How are you, ma'am?
Sorry, I'm fine. I'm Michelle. I just wanted to ask you, I noticed you mentioned that YouTube music, there is that clause of fair play, when you're listening, when you're screening music to see if it'll be suitable for the station.
Right.
Or you're listening for your own self.
Right.
But say you actually start to play those songs on air, we've worked out a system where then we download those songs onto CDs and we give a SAMRO number to it and register it with SAMRO. Is that necessary, or is YouTube music able to be played on air, or is that when it starts to be the money side of it?
I'm glad you asked that question. basically YouTube is putting the music out there for review, right? For you to listen to it, for you to stream it in real time. The moment that you download the music, you're actually making a copy of it. So you're making a copy of copywritten work. And then if you are maybe playing it at the office or even performing it or playing it through a diffusion service, then that would be an act of copyright infringement. So I think I'm not necessarily going to endorse your practice, but at least you're not stealing.
Yeah, great. So because sometimes the music is unavailable,
right?
But if you make a CD copy, but solely for the rights of giving it a SAMRO number, and then when we pay, then obviously then the artist will get money, because we thought, and then we don't use the CD for any other use, just for our library to get the music, and then the artist will benefit in the end. So is that okay? Can't you say?
May I request that you refer to the screen right now and take my email address, because we are digressing a little bit from cyber criminality, and I'll be more than happy to take this question offline. Is that fine with you?
That's fine with me. Thank you so much.
Okay. Right. Let's see. Mxolisi, are we finally getting you to talk? Because your mic looks on. Okay, Mxolisi will get back. Bongani Ndlondlo, I recognize you. Please switch on your mic.
Good morning.
Hi, good morning.
Yes. My question would be something that you mentioned earlier on regarding laying a charge at a police station. I didn't quite catch that. Are you saying when you get to a police station to open a cybercrime charge, there are designated people to handle such a case, or you need to go to a certain place specifically, or what's going on there? I just need clarity on that.
Okay. No, what I was saying, in terms of this act, the SAPS must create a central point. So there will be a phone number or an email address or a specific central office that will be specially designated for the laying of cyber criminal charges and instituting them as well. Because of the difficulties that we've experienced in terms of police who are either not properly equipped or don't understand. So there will be a central point. It may be a website with a phone number and a dedicated telephone number as well. Does that explain it, Bongani?
Oh, no, it explains. So which means we do not have something like that currently.
Right. So in terms of the new act, the police must create that. And hence I'm saying I take my hat off for that, because that is the right move in the right direction.
So, right. So in the meantime, while we still waiting on to have something like that, what can a complainant do in such a case?
Look, you obviously will have to go to your local SAPS office, and unfortunately, you may have to tell them in what terms of section the issue is. I've had instances where I've had to prepare complainants' affidavits because the police officers were not able to assist the clients. So that's a little bit of a snag, but I know that there is now education happening within the police service. I know that. And so, you can go, you can report your case. You'll just have to follow up and make sure that your matter is getting the right attention.
Okay, thank you.
Thank you there. Okay.
Am I audible this time?
Yes, hi, Mko. We can hear you now.
Yes, good morning, colleagues. My name is Mkolisi from the UTFM. Yes, I wanted to find out, does this act protect people that are affected when people are using social media for smear campaign, like just defaming them?
Does
using
this
all
act
these
protect?
Yeah.
You mean, does this act protect victims of a result of defamation. Is that what you're asking?
Yeah, smear campaign or defamation, yes.
Yeah. Well, look, we still have the Hate Speech Act, remember? Remember I referred you to that? Okay. And I also referred you to section 14 and 15. Remember, the one where social media is being used to either incite violence against you. But later on this morning, when we talk about defamation in the online media space, I will discuss several cases dealing with online defamation, in particular, the quite recent cases. So if you don't mind, Mglo, let's park that question for the later session. But I will remember that you asked it.
Yes, just to add a little bit.
Yes.
Can it also talk on the fake news on social media? Because some of these news are misleading and defame or affect.
You know what? We've considered, and when I say we, I'm talking about as academics. We've considered the criminalization of fake news, and if you look at the criminalization of fake news in Eastern African countries, as well as our neighbor Zimbabwe, the criminalization of fake news, although it has a good intention to put away those who are spreading fake news, it could also have a ripple effect where now you are being accused of spreading fake news, and for whatever political reasons or other malafides, you may be prosecuted. So fake news in terms of our legislation does not get prosecuted.
Prof, there's a question in the chat function.
Okay. Let me go there.
Yeah.
Okay.
And Prof, before you answer that, can I also just ask a question in relation to revenge porn and child pornography?
Okay, just a second. I'm reading this question. Sorry. Yeah. Okay, you were saying?
No, can I also just ask a question in relation to revenge porn and child pornography?
Yeah, sure.
If in an event, so I mean, community media platforms have social media pages. In an event where one of the audiences was to upload an image that would be considered as child porn, or a video that would be considered as child porn or revenge porn, who would be liable in terms of prosecution in that regard? Would it be the person who uploaded it or the radio station or publication?
That's a very tricky one, but criminal law, unfortunately, is not as wide as civil law. See, if we were going to talk defamation, I was going to say he or she who uploads it and the irresponsible station manager or the irresponsible editor. That would be in the case of defamation. But when it comes to child porn, I guess anyone who possesses child porn, anyone who makes it available, anyone who uploads it, hence I made reference to that specific slide where all the instances are mentioned. Anyone who makes it available, anyone who shares child porn, all those particular instances are acts relating to child porn. There's about 10 of them. So it would most probably be that person who's uploaded it. I doubt we could extend the liability to the station manager in terms of criminal liability, unless the station manager somehow was associated to that upload or authorized it. Are you with me?
Yeah.
Okay. So let me read this question. This question comes from, just a second. Okay, who's this now? From Mutu. Oh, Mutu Bumela. Okay, right. Morning, everybody. My name is Mutu Bumela from Alwell North, Eastern Cape. My question here is about the porn or nudes. If maybe you have your ex's porn or nudes, then you lost your cell phone, then someone publishes the nudes without knowing. Okay. I'm glad you didn't post as anonymous. But obviously, the crime of revenge porn requires intention. This takes me back 20 years back, by the way. The criminal law is a deductive way. The intentional and lawful sharing of so because you said that you may have lost it or the person who you are seeking advice for, that person who may have lost the phone, he or she did not intend, so the intention falls away automatically. So if eventually that phone goes into the wrong hands, that person, if we can catch that person and identify that person, he or she would be the one that we charge, not the person who had the porn and the nudes. But my advice as a cyber lawyer is keep that stuff away from your phones, keep that stuff away from your hard drives. These things always get lost. Right. Are there any further questions? I'm just looking at the time. Right. Okay, what we're going to do now is, unless there's any further questions, or are there further questions? Let me ask.
Yes, sir.
Okay.
Yes, sir, there are. Yeah. On the issue of recordings that are made, like take conversations, but the other person, the other party does not, is not aware that it's been recorded. Can that be used in the court of law?
You see, now you're asking about privacy. Mko, let's deal with privacy during privacy.
I'm just throwing it to you. You're a cyber lawyer, so I don't know that you have your things in order there, your agenda and stuff. So
yes, but you will recall at the beginning, we said we're going to do cybercrime at the beginning. Then Advocate Ngogweni is going to do POPIA. Then privacy online, which is what you are asking me about now, and then freedom of expression. So let's compart those questions at the right time. And I don't want us mixing up the issues. Okay?
No. Understood, sir.
Okay, thanks, Mko. All right. Are there any other further questions? I see there's a hand from MDDA. Okay, let me see.
Sorry, that was earlier.
Oh, was that you? Okay. Well, if there's no further questions, we've finished about 2 minutes early. In terms of our planning, we are going to have a 5-minute stretch break, just to stretch your legs. For those of you who need to attend to the restroom, and then at 5 past the hour, Advocate Ngogweni will then come and do her presentation. So please don't go. Everyone don't go. It's a small 5-minute break, stretch break, just also to allow Advocate Ngogweni to set up here. And then at 5 past the hour, we will proceed. Okay, thank you.
Good morning, everyone. I'm Advocate I will be presenting on Protection of Personal Information Act awareness. As we all know that the Protection of Personal Information Act was passed into law in 2013, but it was not fully operational. It became fully operational on the 1st of July, 2021. All companies were given 1 year grace period to comply with POPIA. The information regulator started to enforce all the provisions of the Act from the 1st of July. The purpose of the Act is to give effect to the right to privacy as provided for in Section 14 of the Constitution. It's also to regulate the way in which personal information is processed, as we all know that most of the business are conducting the business online, and we're gradually moving to an online space. So one needs to make sure that when processing personal information, they do it in accordance with the provisions of POPIA. The other purpose for the Act is to balance the right to privacy against other rights, such as the right to access to information and the right to freedom of expression as provided for in Section 16 of the Constitution. Further, the Act also guard against the abuse of personal information. It also provides or grants data subject with the rights and remedies where personal information is misused. Lastly, it establishes the information regulator to ensure that the provisions of the Act are complied with or are adhered with. Now we're going to be looking at the establishment and the composition of the information regulator, which is the mother body or the body that makes sure that the processing of personal information is done accordingly to the provisions of the Act. The information regulator is established in terms of Section 39 of POPIA, and this provision provides that the regulator is a juristic person and has the jurisdiction within the borders of South Africa. It is an independent body that is subjected only to the Constitution and the law. It is required to be impartial and to perform its function and exercise its powers without fear, favor, or prejudice. And it is also accountable to the National Assembly. Now, surely everyone asks themselves, who does POPIA apply to? Who has to comply with the Act? And how? POPIA applies to all the processing of personal information, even though maybe the company or your organization does not use personal information for day-to-day activities. The organization must still have personal information of the customers, the employees, and the suppliers. Therefore, the organization still needs to comply with the provisions of POPIA. So POPIA applies to all the processing of personal information which is entered into a record. It can be automated record or non-automated record. By record, I refer to writing of any material, information that is produced, recorded, or stored on tape recording as a computer equipment or any other device, such as your phone, your laptop, photographs, films, books, maps, drawings, and graphs. They also form part of the record that is processed by the responsible party who are domiciled within the Republic of South Africa. Remember what I said, that the Act only applies within the jurisdiction of South Africa. Now, one wonders what this personal information stands for, or what is it? Personal information simply refers to any information about identifiable living person or a company, which includes, but not limited to, your date of birth, your identity numbers, your email, your race, gender, etc. Now, in the processing activity, we find parties that are involved, which are very, very important to actually explain, so that we can have a clear understanding of who is involved in the process of processing of personal information. Firstly, we have the data subject, which is the person or the company to whom the personal information relates. And we have the responsible party, which is the person who processes personal information. And thirdly, we find operators. Operators are mainly a person or companies that processes personal information on behalf of the responsible party. Then we come to the definition of processing. Processing means any operation or activities or any set of operation, whether or not automated, means concerning personal information, including collection, reception, receipts, record organization, collation, storage, updating, modification, alteration, consultation, and the use, dissemination by means of transmission, distribution, or making available in any other form, merging or linking. So basically, processing involves any action or any act that you do with information. It can be collection of information, dissemination, updating, modification, amending, consultation of material, or using part or full of information. That also forms part of processing. Now we come to the conditions that are prescribed by the Act, which must be complied with when the processing of personal information takes place. POPIA prescribes 8 conditions which the responsible party who processes personal information in general must comply with these conditions. The first condition that I'm going to be discussing is purpose specification that is provided for in Section 13 of the Act, which stipulate that personal information must be collected for a purpose that is specific, explicitly, meaning that is clearly defined, leaving no room for confusions or doubt. And the purpose must be lawful. Having the purpose is not enough. The purpose needs to be lawful. It has to be justified. After the processing of personal information must be destroyed after the purpose for which it was collected has been completed. Meaning that if the purpose for which the information was collected come to an end, then such information must be destroyed. Or personal information may only be further kept for statistical research purposes or for historical purposes, provided that there are proper safeguards in place to make sure that such information is protected. And the second principle that I'm going to be discussing is openness. Openness is provided for in Section 17 and 18 of the Act and provides that the data subject must be aware of the reasons for collection of personal information and must be notified prior to the processing of personal information. So the responsible party must make sure that the data subject is notified of any processing activity prior its activity being done. And the third condition that is also important is the data subject participation, which basically requires the data subject to have access and to have the right to control, correct, delete, and have access to personal information that is processed by the responsible party. Further processing limitation, that's the other condition that the responsible party must comply with when processing personal information. Further processing must be compatible with the purpose for collection, meaning that if the information was collected for a specific purpose, and then now that the responsible party want to use or want to further process the information, then there should be a link between the information that was collected prior and the purpose for which the information is going to be further be processed. Then the other principle that is also important and is prescribed by the Act is information quality. The information must be accurate, it must be complete, and it must be up to date, and should not be misleading. Moving right along, the other condition is security safeguard that is provided for in Section 19 of the Act. Personal information must be protected to ensure integrity and confidentiality of the data subject. Security measures must be put in place to prevent loss, damage, and unauthorized destruction of personal information of the data subject. In terms of Section 19(2) of POPIA, it provides that in order to give effect to Section 19(1), the responsible party must take reasonable measures to ensure that they identify all the reasonable foreseeable internal and external risk to personal possession or information that is under their possession or under their control, meaning that the organization must go an extra mile in terms of identifying the possible risk that could lead to the breach of POPIA or to the breach of the rights of the data subject in terms of processing, to establish and maintain safeguard against the risk identified. That is to make sure that the security measures that are put in place are being maintained and to make sure that all the risks that are identified with are dealt with accordingly. Regular rectify that the safeguards are effectively implemented. It is not enough just to put security measures or measures in place to make sure that there is no breach. The responsible party must also go an extra mile to make sure that they verify time to time to make sure that the security safeguards that are put in place are effective. And to make sure that the provisions of Section 19 are adhered to, the security safeguards that are put in place must continually be up to date in response to new risk. Should the responsible party be aware of any breach or any unlawful processing of personal information, it is the responsibility of the responsible party to notify the data subject of such breach. Coming to accountability, the responsible party must handle information in a lawful manner and also ensure that compliance with the condition of processing are adhered to. So basically, to make sure that all the conditions that are provided for by the Act are complied with. Coming to processing of special information, POPIA prohibits the processing of personal information such as information relating to religious or philosophical belief, race or ethnic origin, information that relates to trade union, political persuasion, health or sexual life, biometric information of the data subject. As I said earlier on, that the purpose of the Act also forms part of protecting the rights of the data subject. Section 5 of the Act clearly set out the right of the data subject, which are the right to be notified that personal information about the data subject is being collected, as well as the right to know when his or her personal information is accessed or acquired. Secondly, the data subject also has the right to establish whether the responsible party holds personal information of the data subject and to request the responsible party to access his or her personal information. Basically here, if the data subject wants to establish what information does the responsible party has, he or she must have that access, and also has the right to be notified, as I said earlier on, of any information that is collected prior the collection. The data subject also has the right to request, where necessary, that his or her information be corrected, be deleted, or be totally distracted. If there's a reasonable ground that the data subject in a particular situation feels that such information infringes his or her rights, then he has the right to request the responsible party to delete such information. The other right that the Act provides to the data subject is to object to the processing of his or her personal information at any time for the purpose of direct marketing in terms of Section 11(3)(b), alternatively in terms of Section 69(3)(c). The latter provides that data subject has the right to object to having his or her personal information processed for the purpose of direct marketing by means of unsolicited electronic communication. Furthermore, the data subject has the right not to be subjected to, under any circumstances, to any decision which is based solely on the automated processing of his or her personal information intended to provide a profile of such person as provided for in terms of Section 71 and 5. And lastly, the data subject has the right to submit a complaint to the regulator regarding the alleged interference with the protection of personal information that is provided for in terms of Section 74 of the Act. There are exemptions that are provided for in the Act. The regulator may exempt processing of personal information if it is satisfied that it is in the public interest and involves a clear benefit to the data subject or the third party to process information. What is it? When we speak about public interest, we're basically referring to the interest of national security, prevention, detection, and prosecution of offenses, important economic and financial interest of the public body, fostering compliance with legal provision, historical, statistical, and research activity, special importance of the interest in the freedom of expression. So that is basically public interest. Personal information processed for the purpose of discharging a relevant function. That is the last thing. The other exception is where the data subject has provided a consent. Section 11 of the Act provides that personal information may only be processed with the consent of the data subject and the consent of the competent person in relation to children. Consent is only voluntarily and informed expressly of a will in terms of which permission is given for the processing of personal information. So basically here, the other exemption is that information can be processed where the data subject has given consent. In the case of children, the parents can give consent of the information that has to be processed relating to the children. Now let's look at processing of information that is subject to prior authorization. I can see 2 hands. I will allow questions once I'm done with the presentation. So for now, can you just jot down your questions? And then after the presentation, you will come in. I note you, Gidu. You are noted. Moving right along, I'm going to be now dealing with the processing that is subject to prior authorization. Section 57 requires that if responsible party wishes to link personal information connected to unique identifier for another purpose other than that which was collected for, which means if the responsible party wants to further process the information that was collected, but for another purposes, which is different to the purpose for which it was collected. Specifically, information connected to unique identifiers. By unique identifiers, it's information such as your ID numbers, information that can be linked to a data subject. The said responsible party must seek prior authorization from the regulator. Basically, the responsible party must apply for prior authorization online or by completing forms that are available on the website of the Information Regulator South Africa. Then the Information Regulator needs to reply within 4 weeks, conduct investigation when necessary, before it can issue the authorization for the processing of personal information. Prior authorization is also required where data subject unlawful or questionable conduct is processed, or where criminal conviction information is being processed, or information is processed for credit reporting or special information, or personal information of children is being processed in other country that does not have the level of protection in terms of protecting personal information. Now I'm going to come to direct marketing. Section 69 of the Act provides that the responsible party can only process personal information of the data subject for the purpose of marketing if the data subject has given consent for such processing. And also, the consent must be voluntary, specific, and informed expression of will in terms of which permission is given for the processing of personal information. And the data subject also has the right to opt out to direct marketing. Now I'm going to discuss consequences for non-compliance with POPIA condition. If the responsible party fails to comply with the provisions of the Act, the data subject can lodge a complaint with the information regulator. On the receipt of complaint for interference with the personal information, the regulator must conduct full investigation and refer the complaint to the enforcement committee for consideration. The finding in respect of the complainant and the recommendation in respect of the proposed action can be taken by the regulator. Then the enforcement committee may take any recommendation to the regulator on any action that should be taken against the responsible party, and that is provided for in terms of Section 93 of POPIA. The regulator may, after considering the recommendation of the enforcement committee, serve the responsible party with an enforcement notice requiring the responsible party to take certain actions. On the other hand, the data subject, at the request, the regulator may institute civil action for damages against the responsible party for interference with the protection of personal information. Then coming to penalties that one may face when contravening or acting in contrary with the provisions of the Act, you can get the fine or imprisonment of a period not exceeding 12 months or an administrative fine up to 10 million. One other important aspect that is provided for by the Act is the registration of the information officer that is provided for in Section 55, subsection 2 of the POPIA, to take up on the duty only after they are registered with the regulator. The information officers are referred to in Section 55 of the Act, and they have the duties that they must comply with. Part of the duties that they must comply with is that they must encourage compliance by the body with the conditions. They must encourage compliance with the condition for lawful processing to the organization or staff, deal with the request made by the body pursuant to POPIA, work hand in hand with the regulator in relation to investigation conducted pursuant to Chapter 6 in relation to the body. Regulation 4 imposes additional obligation on the information officer, which I will cover after the Q&A. Thank you. My presentation ends there. I'm going to open hands for questions.
Advocate, there's a question in the chat function.
Yeah. Chat function. Okay.
It's from.
Oh, I see. Is it Kitu?
Yes.
Okay, Kitu, your question: if the employee from the bank discloses financial information to the other members without my approval, how to deal with the matter? From the bank disclose financial. Okay, Kitu. I see. Remember, when processing personal information, one needs to comply with the conditions. One of the conditions is security safeguard and information, it's security safeguard. So with regards to your question, it is unlawful for one to share information or disclose information without the consent of the data subject. So even if you are colleagues, if the processing does not form or it's not part of the scope of employment, then it is unlawful and one is not allowed to do that. I'm not sure if I have answered your question. Kitu, please switch on your mic. Kitu? I see other hands. 3 participants raise their hands. Okay. Attendees. Bongani Dlodlo, I can see you have raised your hands, and Sean. Bongani? Or maybe my mic is off. Okay.
Thank you. No, we can hear you.
Yeah.
I'll just jump in here then with my question. You know, when you said you need the permission of the person in question, yes, when you're sharing their information, say they give a testimony on air or they share some personal information on air, does that permission have to be written? Can it be on an SMS or can it be verbal?
The consent needs to be voluntarily. As long as you can prove that the data subject has given consent, it will be good for it to be in writing, but it needs to be expressly and voluntarily, and it should be provided for by the data subject herself or himself.
Thank you.
Thank you very much, Sean. Kolisi, I recognize you.
Yeah, not a minute change.
Yes. What happens when let's say a newspaper publishes a story, and then obviously this newspaper came out today, and then the radio station further, talk about this story, and later you found out the newspaper didn't do its, didn't investigate or even give the party an opportunity to say their side of the story. Does POPIA Act, protect the people there? Because the station would say, no, it's already in the public. That's what normally happens mostly. They say, no, it's already written in the newspaper. We're just reiterating what was on the paper.
Okay. with this question, I will allow Professor to come in, and you didn't get it. Okay. Nkolisi, can you rephrase your question? Can I repeat what you have just said? You basically saying if someone has given consent that his or her information be published by a newspaper, and then later the newspaper use the very same information because already it's public knowledge, it's there on the papers, to do further processing of such information. That's what you said.
Okay, let me rephrase. I'm saying a radio station finds a story on a newspaper.
Yes.
And then it further talks about the story on the radio. Later you find out the party that was written about on the paper has issues with the station now because the story, I mean, they don't feel, they feel like they were defamed because the newspaper didn't even, give them a chance to say their side of the story. The story was published.
Okay. Let Professor get in for further clarity and to basically answer your question.
I'm Kolisi. Okay, so I see two issues here. I see you having republished something that was previously published. So on the basis of that, if there were any defamation claim, I guess it would be against the party that first published the story, right? Now, if there was any personal information that was in the story and you've republished it, then we must look at Section 7 of the POPIA. Section 7 talks about the freedom of expression of journalists that must be weighed together and balanced with the right to privacy of the individual. And in terms of Section 7, the Press Council Code should provide for codes of conduct for journalists in order to not go over the realm of privacy. So I would implore upon you to have a look at Section 7 of the POPIA, and it talks about this balancing act between the right to privacy as well as the right for journalistic acts. But I don't think there would be any further liability in terms of POPIA because you are not the source of publication. Thanks.
Thank you, sir.
And do we have any further questions? I don't see hands. Okay. We have Nkolisi. Nkolisi Ndongen. I see your hand.
That's me again.
Okay. Do you have any? Okay.
Okay. In an instance where someone committed maybe a criminal act at work, and then now there are people like the employees are striking about this person, and then this story comes to the station through the people that are striking against this person, and the station now gets the clip from a journalist who went there to listen to what the strike is about. The person who was who's been striked against took an offense to say that no, the station does not have a right, and obviously this thing it also has some criminal, like it's going to court.
Yeah. And
the station already has a story. What are we protected there?
Remember, I spoke about exemption. I spoke about exemption, and one of the exemption was that information can be processed if it's in the public interest. So I think that scenario is covered by under exemptions that are provided for by the Act, because surely if someone commits a crime, that is against the law, then it will be in the public interest to actually conduct such processing of personal information. So you are protected in that instances.
Thank you, ma'am.
Okay, thank you very much, Kitu. Are there further hands?
Advocate, there's a question from Sean again in the Q&A, and I think
Yes,
this one is
Shona.
in relation. I think it's in relation to the first session. He's
Yes.
saying, or she's saying, we are finding that the ransomware or /scam emails are getting more difficult to identify. Criminals are getting more creative in creating these emails. Is there any software to install to prevent one from becoming a victim to this? Or is it just that one needs to be extra careful when looking at mail?
Come again.
And so if you click on the Q&A at the bottom, there's a question there.
Q&A,
Yeah.
yes. Can you?
Hi. Okay.
Can you see?
We've got the question here.
Yeah.
We're finding it there. There it is.
Okay.
Let me just answer that. So, in principle, there are softwares such as firewalls that you can install and other preventative measures like Mimecast to try and stop fraudulent emails from coming in. But I always say vigilance is the best. If you know you didn't play the lotto and you apparently now you won the lotto in Nigeria, duh. If you if you know you don't have a bank account in America or you don't have a friend in America and all of a sudden someone is asking you to move money and they're asking you to give money, then, you know, I think vigilance is the key one, you know. It's very, very, very important. Are you with us? Okay, Kitu, do you still have a question there? Is this the one? Who will be prosecuted when police publish a story and
Yes.
announce?
We have answered that. but
We've answered that
yes.
one. We've answered that one, Kintu. How is it that even with this act, one still receives calls from companies? Okay. So this is the POPIA. So yes, in terms of the POPIA, Section 69, you're supposed to opt in terms of direct marketing. And those companies, unfortunately, are still continuing. You would have to refer your complaint to the information regulator, and the information regulator will then comprehensively deal with your complaint. That's the answer to that. Let's see if there's anything there. See if there's something more.
There was a question
Okay,
about
thank
the
you.
previous presentation.
But the previous presentation.
Yes.
See?
Golis, is this the new hand or are you answered?
I see Kintu and I see
Yes.
Kolis's hands. Are these your old hands?
No, it's a new hand. I've got two questions. The first one is, what happens when like a station is applying for maybe funding or anything with an external company, but now obviously we're going to have to use personal information of the board or even the management. And one of the members says, no, I don't want my information to be, shared with externals. What do we do? Because now they're talking about POPIA Act. Now I was faced with this at some point that people don't want to share their information with external companies. They'd rather have the information with the company and that's it. But for external use, they don't want to be part of that because of probably the misuse of their of the information. And then my second question is, it has to do with the banking. Some time ago, I checked my statement. I realized that some of the monies that were taken there, I didn't apply for such things. Are those companies made accountable for such things? Because I think it's fraud. Where did they get my information to start with, and how did the bank agree to that transaction? Thank you.
Should I take it? All right, I'll take the first question. I think I think the radio station needs a lawyer. Let's start with that. Number two, the POPIA is not a prohibitive act, right? And I need to be very careful how I'm answering this one, because I'm not supposed to give advice on POPIA. The POPIA is not a prohibitive act. The POPIA simply says you must process personal information in a lawful manner, as Advocate Ngogweni explained. If the law requires that this processing must take place, if for a contractual situation this information is required, then it will fall under one of the exceptions where you can still process the information, or where there's a public law duty that this information needs to be processed, then it can be processed. So have a look at those exceptions. What was the second question?
It was that of why do we still get SMSs about company?
No. It was the one about the account. Okay, yeah. So Mkolisi, you say you've got debits on your account and you don't know why there are debits on your account. I would strongly suggest that concerning your personal information, the account, that you file a complaint with the information regulator. But I would also think that you should file a complaint with the banking ombudsman, because no one has the right to take money from your account, even from a banking perspective. So I think file a complaint with the information regulator concerning your account details, how those have been received, and in addition to that, you should also file a complaint with the banking ombudsman. See here, in a process of advertising, as a station, we are not allowed to use data from our digital platform to lottery advertisers into buying in. For example, Waterberg FM has an app that captures data like age, gender, and profession of the app user. All right, let's see, who is this? Kamane Gama. Can you just give us an explanation? I see you say you should not be collecting this information, but there's an app that does so. So what is the exact question? If you can maybe just switch on your mic. Kamane? But Advocate, I think what basically is asking about here is the whole issue of notification.
Yeah.
When you go on a website, you know, there must be that notification that we're going to be collecting your personal information. So I think, Kamane, I think this deals with the principle of notification. In other words, if you are going to go on the website of Waterberg FM, there should be like a pop-up that says, look here, if you are going to be accessing our website, we will be processing your personal information.
Yes.
Yeah. What is the
More
POPIA
of
Act?
consent.
Yeah.
When you put your information there, you're basically consenting and you acknowledging that this is your information and your information is going to be processed, I think.
So yeah, it is in terms of the
Yeah.
notification principle. That has to be adhered to. Okay, we've got 3 more minutes before we take our 15-minute break for tea. Are there any last 1 or 2 questions?
There's Kitu.
Kitu?
Police. Ngolis, we recognize your hand.
No, but wait.
Oh, yes. Okay, this goes to the previous presentation. I'm not sure if it's the previous or the current. Let's say a presenter is on air and is taking calls. Someone from the community calls in and start, exposing people there. And maybe the affected person hears the story or she gets the information somewhere. Is the station liable for such? Because other people can really say, you gave this person a platform. It happened in the past and people came to us thinking that we gave this person a platform. So I just want to find out from you guys that are we protected in such? Because we didn't start the story. This person did this thing on his own, but unfortunately they called the station.
Look, as far as I know, radio stations, obviously they can be sued if radio stations publish or say things that are defamatory, which will be part of my next presentation after the tea break. But with that having been said, the radio station can't be held liable for, I guess it was an expose, I guess it was a whistleblowing. So I think in good taste of journalism, I don't think the radio station will be held liable in terms of defamation.
Thank you, sir.
Okay. So we have 1 minute left. Yeah. There's one. Lebogang Matolong, we recognize you.
Thank you so much. I just wanted to just help the previous person. I think there's a thing called a disclaimer, because at times we do not have control over things that people say on air. So like the station can just have a disclaimer that they can't be held personally responsible for the comments that have been made by the caller or the person that maybe is doing the expose. My question, I don't know if maybe like I'm late because I joined in late, was on a call. I just wanted to find out something. Let's say he publishes something on these newspapers, like it has always been happening, and they would have like a next week, it will be a story about Lebogang Matolong, like a big story on the front page of that particular newspaper. Yes. And that information may be false. And then you go and take this up with the newspaper, and then they just send me block of even like I don't even think that my hand is that big, and they just had that, like they put up an apology saying that the story that was put up on the front of the newspaper was false. That information was distorted, and Lebogang Matolong didn't do those. And we apologize to him. How does the POPI Act help in this instance? Because there's been so many instances where like people's names have been tarnished, reputations have been messed up, and nobody is being held accountable. Only an apology has just been sent out. Thank you.
Hi, Lebogang. I think I'm going to nip your question at the bud. It has nothing to do with POPIA. Yeah. Unless there was publication of personal information. For example, the time when the EFF leader's address, home was published, that was in bad taste. That could be something maybe where there could be an issue. But usually if you have any issue with a newspaper, you go to the press council, you go complain there. They will either say the apology was enough or it wasn't, or you should do something more. Alternatively, what we're going to be chatting about after the break, you can go to court and ask for a defamation suit. But stick around, Lebogang. After the 15-minute tea break that we're going to have now until 16 minutes past 11, we will do privacy and freedom of speech. Then yourself and Mqo can ask all sorts of questions.
Thank you so much.
Okay, so we'll talk to you guys at 16 minutes past 11. Thank you for your attention. Let's all have our tea break. Thanks.